Welcome back to Successful Living. Many of my clients struggle a lot with trying to get their estate plan done because they're ultimately talking about dying, leaving that instruction manual, in a sense, to their family. And so we want to bring Lynn Riley in, and Lynn is our estate planning expert from Cameron and Middleman. And hopefully she can help us answer some questions about, not only is it tough to get a client in the office, but when to actually update it. But first of all, welcome, Lynn, and thanks for joining us.
Thank you. Glad to be here.
It's good to see how busy you are when I look at all the paperwork behind you.
Sorry, my office is pretty messy. Sorry about that.
No.
I know where everything is.
So I think, my first question comes in, it's always tough for me to get my clients, number one, to actually, as I said, get them into that office, right? So that's the first thing. But obviously it doesn't end there. Once we get, in the office, get the estate plan done, it's not just a one-time deal, correct?
Correct. You really should review your plan every time you have a significant change to your family or your financial situation, or there's a significant change in the tax law. Otherwise, I recommend pulling it out and reviewing it every 5 years. Now, I have certain high net worth clients that are actively gifting or involved in transactions, and that tends to be more of an annual review.
Okay, and do clients reach out to you, or do you reach out to them? How does that normally work? I mean, are there checkpoints, because everyone's life gets busy, and a lot of times clients think, oh, I got my estate plan done, it's over, I don't have to worry about it until, I don't know, I have a child, or someone passes away, or I win the lottery. So is there usually anything from the estate planner's end where there's some sort of reminder, or is it totally in the client's court?
Well, it really depends upon the firm. We tend to send a reminder out to clients every 5 to 7 years, just in case, to say, check in, maybe you should come in to review your documents. But it's really on the client's side if there's been a change in your family situation. So I usually advise clients when I sit down with them that, if there's been a marriage, a divorce, a remarriage, death or illness of a spouse or an agent, change in your assets, inheritance, or you just feel a little uneasy, there's been retirement, then, come in and call us and let's take a look at your plan.
Okay. So is obviously the initial cost of putting some of this stuff together, and I think this is an older slide if we can get rid of that on that end, but the initial costs versus updating, and can you give some guidelines? Like if that holds someone back that says, listen, I need to update it, but it costs me so much money to put my trust in effect, can that be something that holds them up, and should they really even think about that? I mean, is it not as much as the first time usually, or does it all depend?
It really depends upon the changes that they want to make, but by not changing it, you're just causing more problems later on. Let's say someone was ill, or an agent became ill or died, updating the powers of attorney or a codicil to your will to change a guardian for a child, or the executor, or changing a trustee is pretty simple. So, for example, let's say I wanted to do a one-page codicil to my will and change my trustee and my executor, guardian for kids, and powers of attorney. It could be like a couple $100. I mean, if you're doing a holistic change, you got divorced, or you're putting a plan in place that has a will and a trust and powers, then you're talking more $2,000 or $4,000 if it's an individual or a couple, and depending how complicated the plan is.
But I think you make a great point there, and again, I know it's simple to you and in some cases to me, but by not doing it just causes so many more financial issues down the road that's kind of the big deal with estate planning. Yes, you want to kind of leave your instruction manual, but at the same time you want to save, whether it's your children, brother or sister, you want to save them money when it comes to it. And if you've done the initial plan and you're not updating it, you're not saving them any money.
That's correct, and that includes looking at beneficiary designations and retitling assets. Sometimes people say, I have a will, I don't need to do anything. Well, if you don't title your assets correctly, or if you don't have a trust, you might have probate, you may not think you have probate. So you need to review not only your plan with your advisor, but also how things are titled. How is real estate titled?
Right.
What does your beneficiary designation say?
Yeah, I think we actually have a shot here, if we can put up on the screen, of what documents you should be reviewed. If you can just quickly put those up and quickly chat about those, and when you might have already said that, but if you can just go through those.
Sure. So, look at your financial power of attorney, your health care power of attorney, your will. Your, beneficiary designations are very important, especially changes of marriage, divorce, and so on. both to life insurance and to retirement accounts, your trust, and deeds title to real estate. Those are sort of the documents you want to be looking at.
Okay. And those are all the things that they can do through an estate planner for the most part, correct? Besides beneficiary designation, you may give them, how they should title it, and then they'd have to reach out to their insurance company or, your human resources for 401ks.
Yes, I mean, we do a sheet when we advise clients how we suggest that life insurance or retirement accounts should be designated for beneficiaries. But then we also say, give us copies of your beneficiary designations or the form, and we can provide assistance or review them on your behalf.
Yep. Okay. Now, when someone changes as what they call an agent, so when that name actually changes, what are some circumstances where if you said, I don't know, here's the circumstance for me that if I named, a certain person in my family as a guardian to my child, and they pass away, that's obviously going to be a change. But what other people do you name in estate planning documents that may need to be updated and changed? Like, I don't know if it's certain circumstances that happen or if people get added to your life that are important.
Sure. So powers of attorney for health and finance are probably the most common because obviously marriage, divorce, you want to be changing those. As parents age, my parents were on my financial power of attorney when I was younger and my healthcare power of attorney. Now I'm on theirs. So times change. So, your agent, or if you've just simply become estranged from your agent, you haven't, you had a close relationship, but then they moved away. So anytime you feel a little bit uneasy or there's been a change in circumstance to the health or capacity of your particular agent for executor, the trustee, health agent, financial agent, you should take a look at that.
Okay. Next thing. So we have all these documents in place. And, I've always been told historically my mother or father would have kept it in a safe deposit box somewhere or whatever it may be. But I think we have a slide here of where, you should keep these estate planning documents. Can you kind of walk us through those and tell us the importance that actually you need to make sure that, these are accessible to the right people?
Right. I generally recommend that you keep it in a secure but accessible place like a home office. Many clients of ours have us retain their original documents. We have on-site and off-site vault services where we keep those originals separate from other documents. And then we provide the clients with a book of estate planning documents so they have hard copies, and we also provide digital copies so that they can pull it out and review it every so often. It is not a good idea to put them in a safety deposit box because if something happened and you were to pass away, a special fiduciary might have to be appointed to get access to those documents, such as a will, for instance, in a safety deposit box.
Yeah. Okay. And, one of the things that a lot of clients will do for me is they make a whole list of these IDs and passwords to all their financial institutions and a lot of other things. And I honestly, I haven't asked you this question even offline, but is that the right thing to do? I mean, what do you do, if I have a client that says, I gave all my IDs, passwords, and websites to my daughter, and she'll be able to log in and take care of everything?
Well, I generally tell people, let them know where you keep that information. So first of all, talk to your attorney and your advisor about the best way to protect them. I annually make a listing of those digital assets and the passwords, and I let my financial agent say, I keep these passwords with my estate planning documents at my office or with my, attorney. And quite frankly, businesses now offer secure custodial services for passwords or digital assets. You also want to make sure, quite frankly, that your documents, will, powers of attorney, and the trust have provisions regarding digital assets that allow your agent to be able to access those assets and manage them or deal with them in the event you become sick or die.
So that is something you need to have in the document. Legally you can't just go log in. If let's say a parent passed away, you need, in a sense, a power of attorney probably to do that.
Well, if someone passes away, you want to have the provision in the will and the trust that gives authority to your executor and trustee to be able to deal with those assets. Now, it should be mentioned that many digital accounts and assets have complicated service agreements, so you want to maybe pull out those service agreements and see what it says, but you also want to make sure that at least you have a provision in your will and trust that allows your agent to deal with those assets.
That right there might be the number one reason why you should be updating or revisiting your estate plan, just right there. I know there aren't many people, including myself, that really never even thought about that without that provision in there. How do you handle someone who says, listen, I don't need an estate planner, I don't need an attorney to handle, my affairs, I'm going to do it online myself? Besides the eye raising of, wow, that's cookie cutter, probably incorrect, and you really need a professional for this, what do you say to that?
I say don't do that. I basically, if you try to do your estate plan yourself, even with the downloading of the forms, certain state, every state has different formal legal requirements. A lot of times they're not adhered to, and therefore the documents then can't be enforced, or includes a provision that the client really didn't understand what it meant, and it can result in very expensive litigation for the family down the road. So I say, penny wise, pound foolish. Don't do it.
Yeah, and I think that's always your message is, do things ahead of time, spend a little amount to save the big amount on the back end, and you've always given us, great guidance. Can you kind of end with, and just so, people know how you kind of handle the whole COVID coming in, coming out, this is very, a very thick process sometimes. Do you guys do a lot of online, viewing through Zoom meetings? Do you do in-person meetings? How has it changed so far over the last 5 or 6 months for you personally?
Well, we've changed a lot. So we basically do online conferences. We can do the Zoom conferences, go to office conferences. We now still meet with people if they would like to meet with people, but of course we have to do the social distancing and everybody's wearing their masks. We have signings where it's drive-by signings. We have virtual signings for certain documents. So basically, we've pretty much kept up to date with anything that's available to us to do so that we're safe and they're safe, and everybody is always in touch. One way or another, we're in touch with you.
Yeah. Well, thank you very much, Lynn. As always, you give us great advice to the viewers, and thank you very much for coming on the show today.
You're welcome. Take care.
All right, bye-bye. When we return, we'll won't answer a question. We're going to talk about market corrections and how to prepare yourself for the next couple of months. Stay tuned.